temporarily serving as chair until we elect a chair pro tem and a vice chair pro tem. This meeting is being held in accordance with the Open Public Meetings Act. Adequate notice of this public meeting was given in accordance with the Open Public Meetings Act. Formal action may be taken. Salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. And a roll call, please, Dory.
Joan Furman,
Present.
Michael Josevich, Ken Lowry,
Here.
Michael Leondi,
Here.
Ernie Reichstadt,
Here.
Mike Sylvester,
Here.
Brian Zimmerman.
Here.
We'll just confirm for the record that the oaths of office for all of the new and temporary members of the planning board have been signed and notarized and are in our files. We also want to congratulate Joan Furman and Brian Zimmerman for their appointments and to thank the temporary members from the zoning board, Ken Laurie, Mike Josovic, and Michael Leondi. Mike Josovic is on vacation. We're here tonight on a court-ordered hearing that has to be held in accordance with a court order by May 12th, 2025. We also are here to make sure that we have reorganized the board with membership to fill the disqualified seats, and we have accomplished that. We have some objections to the appointments, but I'm satisfied as board attorney that the appointment of Joan Furman as a designee of the mayor is proper, and she is not in conflict of interest and has never been associated with Sparta Responsible Development Facebook group. In addition, we have a new alternate member, Brian Zimmerman, who also is qualified to be an alternate member of the board and is eligible. In order to achieve a quorum as authorized by the municipal land use law, the board is calling upon the temporary appointment of Ken Laurie, the most senior member of the zoning board, to be a temporary member for this diamond chip application. And I'm satisfied that Ken Laurie is eligible to be a member for this application. We also have appointments or senior members from the zoning board of Mike Josovic and then Mike Leondi. And I have proposed to the attorneys of record that these people be treated as alternates for the board, because without any alternates, 5 people would have to be here exactly every night of every hearing, and that is a hard thing to accomplish for a 5-member board. That being said, the first order of business is to seek nominations for the position of Chair Pro Tem. Are there any nominations for the position of Chair Pro Tem?
I'd like to nominate Ken Laurie.
Is there a second?
I second that.
Are there any other nominations? There being no other nominations, we'll treat that nomination as a nomination to nominate and appoint Ken Laurie as the planning board chairman for the diamond chip application. And a roll call.
Joan Furman,
Yes.
Ken Lowry,
Yes.
Michael Leondi,
Yes.
Ernie Reichstadt,
Yes.
Mike Sylvester,
Yes.
Brian Zimmerman.
Yes.
Now I turn it over to you, Ken, and if you would, please solicit nominations for the position of vice chair.
And Mr. Collins, I can make a nomination too upon soliciting the other members for vice chair. I nominate Mike Sylvester. If there's any other nominations, please forward.
And is there a second for
Second.
Second it.
second? And that'll be treated as a motion to nominate and appoint Michael Sylvester as the chair, vice chair pro tem for the diamond chip application. And a roll call vote, please.
Joan Furman,
Yes.
Ken Lowry,
Yes.
Michael Leondi,
Yes.
Ernie Reichstadt,
Yes.
Mike Sylvester,
Yes.
Brian Zimmerman.
Yes.
Congratulations,
Yes.
Mr. Laurie. Glad it's your job. Mr. Laurie, now we turn to the regular agenda. And before we get started, I'd just like to recommend to the board that we have a hearing scheduled for Diamond Chip Realty. I'd like to recommend to the board that you allow the attorneys for the applicant and any attorneys appearing for objectors to make opening statements so that they can address whatever issues they want to address. I've already decided that you are all eligible, and so I'll respect that they might have differences of opinion on that subject and about whether people can be alternates in this unusual setting of a disqualified quorum. But and any other issues that they want to address that are relevant to this case in their opening statements so that the board can be aware of where they're headed in their cases and what their objections are, including objections as to notice.
Then just one note, if everyone could please respect everyone when they're speaking, professionals, the other people in the audience, your peers, and hopefully no outbursts with cheering and booing, et cetera, and we'll try to get through this at a professional level. Thank you.
Okay, I guess it's my turn. Great to see everybody again. Some new faces. Just by way of a little bit of a recap of how we got here. So obviously we appeared before the planning board on 5 hearings on this application back in 2022. Our last hearing was in July of 2022. The board at that time had identified some issues that it wanted to see incorporated into revised plans. We worked over the next, well, now it's been over a year, on revising the plans and coming up with a proposal that we think addresses those issues. Obviously we had some procedural issues in the interim as well, which is why we have the board constituted here that we have. But really, Tom, I don't have anything further to say on the items that you brought up before. We're just excited to move forward with our application, start our testimony.
Okay, and I think Mr.
This one's not working?
It amplifies, but not as well as the other one.
Yeah, I'll use this.
Thank you, Mr.
Thank
Goen.
you.
Now we'll turn, Mr. Steve Warner is here representing a non-dash, and he and his client may use this table because we have extra seats on the dais, and they can take a moment to get settled. Are there any other attorneys representing any individuals or other parties who are appearing for some other party? Any other attorneys appearing for some other party? Is Mr. Cohen here for the next door neighbor? I think Mr. Cohen is no longer representing the next door neighbor based upon an email I saw from him, but I haven't spoken with him. Just want to make sure that he's not here, and he's not. So, Mr. Warner, please go ahead.
And excuse
Certainly.
me, just for the record, no new testimony after 9:30 PM, and we adjourn at 10 PM sharp. Thank you.
Thank you, Mr. Chairman. Thank you, council, board members. My name is Steve Warner. I'm a partner with the firm of Savo, Shaw, Corsini, and Warner, and it's my privilege to represent the gentleman to my left, Anand Dash, a resident of Sparta and an interested party in this application. I did want to address several matters. I'm not going to address them right now. I was going to list them, and with your permission and with your council's permission, I'll address all of them at the appropriate time. The first, there was a letter, April 29th, submitted by counsel for the applicant. Some of those issues have already been determined by the board. I am pleased that the board, through its counsel, has made a determination that all the duly appointed planning board members, both temporary, borrowed from the zoning board, as we say, and otherwise were duly appointed and are qualified and eligible to vote. I'm also pleased that the pool from which officers could be elected by their fellow board members was not restricted, as counsel for the applicant requested. And I do want to address a couple of other items in his letter. There was a suggestion, more than a suggestion, that this board only has 90 days within which to complete its application in the event that the applicant does not grant an extension of time to act. Respectfully, that's incorrect. You have at least 120 days because, as your board planner has already determined, there is at least one bulk variance at issue along with this site application, a significant parking deficiency. As I think you and probably everyone in this room knows, it is our position that there are other variances at issue, not the least of which would be a D variance that would require this proceeding to proceed before a zoning board of adjustment to get such relief. I'll address that further later. But with respect to the extension of time, again, you have 120 days. I submit because there's a variance at issue. And more importantly, frankly, I would hope applicants' counsel will afford this newly constituted board, the vast majority of whom have not heard any testimony yet, a full and fair opportunity to hear all the testimonial and documentary evidence from all parties, and to give the members of the public behind me a full and fair opportunity to afford them their right of due process under the state and federal constitution and their rights of confrontation to participate fully in these proceedings. Another matter that was addressed, in my opinion, unfortunately, in the April 29 letter by applicant's counsel was the suggestion that my co-counsel, and I appear here as co-counsel to Robert Simon of the Herald Law Firm, who also has been retained to represent Mr. Dash. For reasons outside the control of Mr. Simon, he could not be here this evening, and for reasons outside the control of Mr. Simon, this matter was unable to be adjourned past this evening, so I appreciate you giving me the opportunity to be here in his stead. He represents Anand Dash, as do I, a resident of Sparta, and by definition an interested party under the municipal land use law. I think it's a thinly veiled attempt at best when applicant's counsel tries to suggest that Mr. Simon actually represents a broader group, perhaps anyone who ever clicked on the Facebook page for Sparta Responsible Development, because as the board and its professionals know, and perhaps members of the public know, but if they don't, let me tell them right now, that's an attempt to prevent members of the public, and a vast number of them as I understand it, an opportunity to ask questions of the witnesses of the applicant. Mr. Dash is required to ask questions through me and Mr. Simon when he is here. I respectfully submit every other member of the public has the right to ask questions of each and every witness, and they should not be their constitutional rights should not be encroached upon by trying to limit or restrict or prevent them from doing so. Those are the items that were addressed in Mr., and I apologize if I'm pronouncing it, Gowen's, that's why I said applicant's counsel, Gowen's letter of April 29. I also intend to argue in support and supplement Mr. Simon's letter of April 24, wherein he pointed out one in particular, deficiencies in the content of the notice by the applicant. As this board knows, notice is jurisdictional, meaning it's a predicate for this board to act. If the notice is bad, you cannot proceed. I can make that argument now. It probably makes sense to make it now. It's a predicate argument, and it's no surprise that applicant's counsel, who I suspect will argue to the contrary. The applicant, however, failed to provide adequate notice. The MLUL's fundamental requirement is that the public must be fairly apprised of the application and any related hearings in order to consider it. That's Section 11 of the Municipal Land Use Law, and the seminal case is the Pearl Mart case. I often like to say, as most of the time I'm a board attorney, I usually fall back on Pearl Mart and its progeny. Pearl Mart's the case that is almost universally relied upon for content of notice and sufficiency of notice. The public notice requirement ensures that members of the general public who may be affected by the nature and character of the proposed development are fairly apprised thereof, so that they may make an informed determination as to whether they should participate in the hearing, or at the very least, to look more closely at the plans and other documents on file. There's 4 items that must be in every notice. Date, time, and place of the hearing. They got it right on that one. An accurate identification of the property proposed for development by street address. Actually, technically, it's or block and lot, and it actually is or. You can get away with one or the other under the case law. They got them both here. So they're 2 for 2 thus far. And the location and times at which any maps and documents for which approval is sought are available. And that was done as well. The problem is with the content of the notice, and specifically the requirement that the nature of the matters be considered. And there's a plethora of case law on the issue, not only when the matters considered are not specifically enough identified, but also when they are identified in a way that can be to the members of the public misleading. To properly put the general public on notice of the nature of the matters considered and the character of a proposed development, it's imperative the notice of hearing contain an accurate description of what the property will be used for under the application, and where the notice fails to give a reasonably accurate description, adjacent landowners may be misled. Notice is fundamental to the board, and it's a matter of jurisdiction. My client has originally raised a legal issue before the board, as you're well aware, and it's been before the courts. To summarize that issue, it's the issue of whether or not this proposal is as purported to be a project for a warehouse use as defined by the Sparta zoning ordinance, or I should say land management code, or something different. Perhaps a truck terminal, which is not a permitted principal use, but a conditionally permitted use. And as this board, particularly the Zoning Board of Adjustment temporary members know, if you violate any one of those conditions for that conditional use, that is a D3 variance that is required, and only the Zoning Board of Adjustment has jurisdiction to hear that application. Or it may be that it is some other non-permitted, ergo prohibited use that requires D1 use variance, be it a combination of uses, principal uses, or a single principal use, all of which, frankly, there was evidence in the prior proceedings back some 2 years ago, and no doubt will be more to support those contentions. But regardless of the outcome of that issue, that is an issue. And the court ruled that the planning board can make that interpretation of that issue. What is the correct use? Is it truly a warehouse, or is it something else that might have ramifications as to jurisdiction of the planning board? Excuse me. However, that did not appear in the notice. And in fact, the notice misled the public by affirmatively stating, in essence, that issue's already been resolved. Why do I say that? And first, let me go back to the judge's decision that I was referring to, because the board needs to consider testimony and evidence submitted by the applicant, who per the appellate division's decision that came out just days ago, the applicant has the burden of proof to demonstrate that the purpose listed in its application was for a permitted use in the ED zone as a warehouse. That's their burden. As board members, you know, the applicant has all the burdens of proof. That's one of them. The appellate division stated on page 6 of its decision, and it recognized this as it sent this case back to you, and when I say you as a planning board. In essence, DCR, Diamond Chip Realty, has the burden to show the purpose listed in its application was for a permitted use in the zone as a warehouse, and the planning board would decide whether it met that ordinance. If the planning board decided the application was not for a warehouse, the zoning board would then have jurisdiction to hear any further applications by DCR. That's a quote from the appellate court. The notice fails to notify the public that the board will determine if the proposed use for the subject property is permitted, conditionally permitted, or prohibited. Instead, the notice misleadingly states that the applicant is proposing, quote, a rail-served warehouse storage facility, a permitted use in the ED zone, end quote. As if you've already decided that issue that the appellate division directed you to decide in these proceedings. That's not just failing to include something that's required to be included. That is actually affirmatively misstating the facts and the issues before this board and leading members of the public to conclude that the issue's already been resolved. That, when we talk about, and I don't mean to analogize this to fraud, but there's two types of fraud under the law. You can make a material omission, fail to state something that's material, or you can affirmatively make a misrepresentation. Here, it was an affirmative misleading. I do not accuse anyone of fraud. But the notice, nor do I have to, the notice was deficient because it not only failed to state that this issue is before you, but it affirmatively misstated that it's not before you, that it's already been resolved. Health Division told us, no, it hasn't. It's your job. Further, the notice fails to mention that prior public hearings on the application took place approximately 2 years ago. Whether the proceedings that took place at such time are still to be considered a part of the record before the board in considering the application, notwithstanding the fact that we have almost all, if I understand correctly, new board members to hear this application as planning board members, or the extent to which the application has been revised since that time, which I think we all know is very substantially amended since 2 years ago. In fact, it's been amended twice since the prior proceedings for the prior application. Without clearly and accurately setting forth the nature of the matters considered as identified, accordingly, the public notice is both procedurally and substantively deficient, divesting the Board of Jurisdiction to begin to consider the application at its May 1, 2024 meeting. There's no close counts in the law of notice. If it's deficient, as I just described, you can't proceed. You can't begin because everything you do thereafter will be a nullity, will be void, and you'll have to do it again. I want to reserve my right to argue further, including respond to applicant's counsel, who I have no doubt will say that the notice was sufficient. But I do want to end by urging you and reminding you, you got to do it right from the start. I think we've all learned that as doing board work, particularly those of us who do it nightly, weeknightly. Thankfully, only weeknightly. The want to do it right from the start so you don't have to do it again. On that issue, I do have other issues, but I spent a lot of time, and I think it's only fair that I give applicants' counsel an opportunity to respond to my argument.
Sure. So,
Wait a minute, gentlemen, let's do all of Mr. Warner's objections, and then do Mr. Gouen, and then both of you get a chance to address anything either says, but also if there was a hidden issue in what Steve Warner was talking about, which was something about the prior meetings. All the board members except Mr. Leondi have reviewed the entire prior record and so certified, so just putting that on the record. But I want to know whether the objector, Mr. Dash, and Mr. Warner, his attorney, contend that the prior record is not part of the record of this application, amended application now. And then I'll want to hear that from Mr. Gouen as well.
Well, before I make the argument as to why, it is our position that the record is such that the proceedings must, as a matter of law, start anew with this new board, given that, among other things, and I'll make the full argument, assuming we don't have agreement, but I'll hold for now. My position, my client's position is we must start anew, and I'll explain the half a dozen separate and independent reasons why the law requires that.
Excuse me, Tom, maybe you should explain that now?
Yeah, I think go ahead and, I need to hear what Mr. Warner's position is, and then I need to hear what Mr. Gouen's position is on the record.
Okay.
And I respect, this is a very important issue, so let's air it out. I want to hear both sides on this very important issue.
Certainly. What is the record? The proceedings must start anew for multiple separate and independent reasons. First, the unique circumstances that we all find ourselves in. I can assure you I've been doing this for 30 years, very primarily as a board attorney, candidly, and municipal attorney. This is a new one. Virtually the entire board, as I understand it, are new.
Steve, there is one member, Mr. Sylvester, who was here for the prior entirety of the prior application. Mr. Reichstad was appointed after the prior application, so everyone except one. And then some of the zoning board members were here for the interpretation application by Mr. Dash, but that's different and not that record.
Thank you, Mr. Collins, and that's exactly right, and that's what I was referring to as virtually. That's what we attorneys do, right? When there's one, you say virtually everyone. It wasn't here before. That is unique. What's also unique, let's take them in combination, is the fact that there were 5 hearings that took place approximately 2 years ago. And let's also take into account the fact that the plan substantially changed, and I'll get to that more in a moment, twice since then. In fact, when I say it's a unique circumstance or an unprecedented circumstance, I'm not alone. In fact, applicants' counsel, one of them, Mr. Garcia, who is an attorney for Giordano, Halloran, and Cicela, who handled the litigation, correctly, in my opinion, characterized in a April 9th law news article, such a large scale, and I quote, such a large scale, the article, I assume the article quoted Mr. Garcia correctly, such a large scale disqualification appears to be unprecedented. Now, under such circumstances, the board's reliance on dry, stale transcripts from 2 years ago dealing with essentially a different project as the project that's before you tonight, cannot supplement or compensate for what you're missing when you're reading those transcripts. You cannot see and hear, particularly see, the testimony coming in. As you know, you are fact finders. You are judge and jury, if you will. And you know, among other things, your job is not to just read what people said, but to see them in real time say what they're saying, particularly under cross-examination, and assess their credibility. You can't assess the credibility of a bunch of pieces of paper. So much for the dramatic portrayal of what a bunch of pieces of paper look, right? All right? I think that you can do. You can picture that. But you can't judge the credibility. In fact, I was part of the group that when COVID first hit, we tried to figure out how we're going to do these remote meetings. And I apologize for digressing a bit, but I think it's relevant. We had to come up with rules that ultimately turned into regulations for handling remote proceedings. We're all familiar with them. Well, not long ago that we were all doing them, right? And there was a separate set of regulations permitting remote proceedings for land use boards. I'm sure Mr. Collins taught you, or Mr. Keynes on the zoning board taught you, that it's a different set of regulations for land use boards hearing development application hearings, different than any other public body. Why? Because you're performing a quasi-judicial function, you're judges and juries. And you have to be able to see and hear and assess credibility. That was the whole point of it. A whole different set of supplemental regulations that we had to create and weave our way through to make sure what? People had full and fair hearings and due process rights under the state and federal constitution were afforded. And this is not the typical situation that we've all experienced, and that's provided for in the MLUL under Section 10.2, which allows for a board member, and in our experience, right, one or two board members might miss one or two meetings in a multi-hearing process, right, happens, and you're entitled in that circumstance to read a transcript, or preferably watch an audio-video recordation of the hearing. I know you didn't have that opportunity, unfortunately, here. In order to qualify yourself after being absent from a meeting or two. That's what that statute was enacted for. To be able to handle that efficiency to keep the process moving. Not for, as Mr. Garcia aptly characterized it, this unprecedented situation to substitute for you as new board members hearing a new application and not an old one reading about it from 2 years ago. That's just one reason why legally I submit we have to start anew. Separate and independent reason. The prior 5 hearings, by virtue of Judge Minkowitz's ruling on March 28th, are void as a matter of law because he determined that any member, which effectively, as I understand it, was any follower, if you will, of the SRD Facebook page, had to be disqualified from the proceedings. And it's my understanding, and I have documentation demonstrative of such that the former chairman of the planning board, Andrew Reyna, who presided over, I believe, all 5 hearings, was, at the time, a follower, member, so to speak, of Sparta Responsible Development. There's a case on this. When was the last time you heard a lawyer say there's not a case on this, right? There's a case on this. Randolph v. Brigantine Planning Board, 405 NJ Super 215, the Appellate Division in 2009. The court determined there that the chairman's recusal from the application before deliberating and voting, the chairman didn't deliberate and vote, recused, but had participated prior in a prior hearing. That recusal tainted the whole process, requiring a do-over. And I quote from that case, "In sum, because of Chairman Roberts' participation at the December board hearing, the board proceedings in their entirety must be voided and set aside." Similar case, Haggerty versus Red Bank Borough Zoning Board of Adjustment, also an appellate division decision in 2006, cited at 385 NJ Super 501, also set aside the decision of a board of adjustment because of a conflict of interest on the part of the board's presiding officer. Could have just said chairman, but the court said presiding officer. Those cases are on point, in my opinion, and respectfully to former Chair Reyna, his participation in those 5 proceedings 2 years ago tainted them. As a matter of law, do-over, as the court ordered, the appellate division ordered in the Randolph case. Third, separate and independent reason. This project and the plans, as I alluded to earlier, have been substantially amended since the prior hearing in 2022. You don't have to thank you. And done so twice, as I understand it. Thank you. Both, the application went from 2 buildings and at one point shrunk to 1 building that was somewhat smaller than the combined 2 buildings in square footage, gross floor area, and now is back to 2 buildings and back up to about, 698,000 square feet in gross floor area. It's well-settled law that where an amended application is substantially different from the original, it may be treated by the board and any reviewing court as a new application. And I'm citing not from the appellate division, the Supreme Court of the State of New Jersey, 10 Starry Dom Partnership versus Morrow, 216 NJ 16, a 2013 decision. In such a case, the court said, new notice must generally be given of the filing of the amended application. And in a similar case, Lakeshore Estates v. Denville, getting a little closer geographically, 255 NJ Super 580. That's an appellate division decision in 1991, affirmed by the Supreme Court at 127 NJ 394 in 1992, where an amended application sought approval for a substantially revised site plan. The application was deemed a new application and new notice required. And that rule holds even where the application and the project are amended such that they require less relief or relief of less of a magnitude. Or it got smaller. The court doesn't say, well, it's a new application. If there's a substantial change, increasing, but not decreasing. A substantial change is a substantial change whichever direction it goes. And for that, I cite Macedonian Orthodox Church v. Randolph Planning Board. The first one, Randolph, was a gentleman by the name of Randolph. Now we're in Randolph. 269 New Jersey Super 562, Appellate Division 1994. The court held that even though the plan changes eliminated the need for some variances, where the changes themselves are substantial, the application can be treated as a new application and reviewed anew. Start anew. As I said, as I understand it, Diamond Chip applied in November 2021 to build 2 warehouses with about 880,000 square feet of space. The size was later reduced to about 660,000 square feet in one building, if I recall correctly. And now it's back up to 2 buildings and back up to 698,000 square feet with more than 100 bays, more than 100 dock doors, as we call them. Fourth, separate and independent reason why we have to start anew, why the board, as a matter of law, has to start anew. Again, Judge Minkowitz, in his March 28th decision, already found that Diamond Chip Realty's newest plan constitutes a substantial amendment under MLUL Section 46B. And I quote from page 6 of Judge Minkowitz's March 28, 2024 decision in Diamond Chip v. Township of Sparta Planning Board. Mr. Collins and Mr. Garcia are familiar.
Absolutely.
NJSA 40:55D-46B provides as follows: if the planning board requires any substantial amendment in the layout of improvements proposed by the developer that have been the subject of a hearing, an amended application for development shall be submitted and proceeded upon. And the judge relied on that provision and other facts to determine and to reject the first count of the complaint by DCR against, I guess I could say, this planning board, because you're the planning board now. This planning board. The lawsuit they brought, count 1 was dismissed. That was the count whereby they sought to compel this board to hear and decide the application within 30 days. They'd love to get it done quick, right? Never met a developer applicant who didn't. So I don't fault anyone. I get it. Pages 5 through 9 of that decision go through that analysis, and based thereon, the judge rejected that count and afforded you and the members of the public and the applicant a full and fair opportunity to have a full and fair hearing, what this is all about, and started anew the timeframes, including the 45-day timeframe for the board to deem the application complete. So what am I saying? If I was succinct, I would have said it to you just like this. Judge already ruled it's a substantial amendment. The application and the hearing should start anew. Unique, unprecedented facts and circumstances. Under the law, the transcripts don't do it. The case has to start anew. The former chair's participation in the 5 hearings that they would like to say are in and done, and we could jump off from there. We could springboard from there to get this done quick. They're void because of the former chairman's participation. Pursuant to Judge Minkowitz's decision, they're void as a matter of law. and this is a substantial amendment, as the court found. For those 4 separate and independent reasons, I respectfully submit to you, you have to start anew. And by the way, let me throw one more in. You should want to start anew so that you get a full and fair opportunity to see and hear and judge this case and all the testimonial and documentary evidence on behalf of the applicant and on behalf of all interested parties and the members of the public. I suspect you do. And so I'll add that as a 5th reason. The first 4, you must. The 5th, I respect you because I know you want to, because you know it's the right thing. And I'll stop there for now and reserve my rights.
Thank you, Mr. Warner.
On that issue, I don't know if Mr. Collins wants me to go through every issue.
Oh, yeah,
but
I think
In
it's
fairness
good.
to, but.
No, but I think it's good, Mr. Warner, to, at least, you said you would summarize them, at least summarize every argument you're going to make as if it's your opening, in case the applicant has a counter position that we should hear about as to their opening. I'm not, doesn't mean you're wedded to, you're limited from future presentations or witnesses. But
Certainly. Well, but the other arguments that I have are not, in my opinion, predicate arguments, meaning they're not jurisdictional, nor are they, do they require the board to decide them now, such as what is the record? Are we going backwards with dry transcripts, or are we going forward with a live case? What is the record?
Okay.
Those are the predicate issues. The other issues I have, which are, I'm sure are no surprise, relate primarily to what I alluded to before. There's more than just a bulk variance at issue here, but I think in fairness, that needs to play itself out throughout the course of the hearing. So that's all I have at
Thank
the
you,
front end.
Thank you, Mr. Warner. Mr. Goen, please give your opening.
Sure. So I guess I'll respond to the notice argument first. I mean, obviously, as I stated in my April 29th letter, we disagree that the notice was defective. I'm very familiar with the Lacey case as well. Lacey case has the holding that the notice has to include a common sense description of the nature of the application, such that an ordinary layperson could understand its potential impact upon him or her. Our notice very clearly indicated what we are here applying for. The objectors make a big deal about the fact in our notice that we said that we are making an application for a warehouse, which is a permitted use in the ED zone. I don't think it's in dispute that a warehouse is a permitted use in the ED zone. It's listed among the permitted uses. It is a permitted use in the ED zone. That's what we're here applying for. I think where the mischaracterization comes in is the appellate division holding is not saying that we don't have to advise all of the public of exactly the nature of how the board deliberates or what is necessarily considered in front of the board. We have to give a common sense explanation of what we're seeking, what kind of relief we're seeking in front of the board. We're seeking site plan approval. The board's decision is to determine whether or not our application meets the requirements of the site plan ordinance. We are asking for approval of a warehouse. The board is going to determine whether or not we meet the requirements of the ordinance. We very clearly lay out in our notice exactly what we're applying for. We give a very common sense description. We're applying for 2 buildings. We give the square footage. We outline the parking. Anybody in the public reading that notice would not have any question as to what this application about. We also do put in the notice that this is a continuation hearing, that the board is going to continue its consideration of this application. And so I just find that the argument that our notice is defective for that reason, and that we somehow have to include in our notice, I'm not even sure how that would work. And if you logically play it out, that we have to give some kind of general description of what we're applying to do, a building with employees, with boxes and storage, and then we're going to leave it up to the board to tell us what it is. That's not how anybody notices for a land use application in the entire state. You put in your notice what you are seeking approval for, what permitted use you are seeking. You don't say, I'm coming in and I'm applying for a square building that has a drive-through and a kitchen and we make food and, we're going to let the planning board determine whether or not it's a fast food restaurant, right? I mean, that's essentially what the objectors are saying that we needed to put in our notice, and we're not required to do that. We're asking for approval of a permitted use. The board here is going to determine whether or not we meet the ordinance requirements for that use. So relative to the notice, I think I'll leave it there. Our notice was perfectly adequate under the MLUL, and I think maybe we should decide, Tom, up to you if you want to decide that issue before I move on to the record.
No, I think it's good to go ahead and address these
Yeah,
issues
okay.
that Mr. Warner has highlighted, and maybe we'll deal with all of those.
Well, I'm going to try to, I'll move to our notes on the record. I mean, I think it's really important that the full record of this case be considered when the board is adjudicating our current version of the application. I mean, even if you're reading the transcript, there's a lot of information in the transcripts that's relevant to what we're going to present what we're going to present tonight. And, part of the reason why we are here with an amended plan is because of all of those 5 hearings and the comments that we got from the planning board and the comments that we got from the public, and particularly at that July 6, 2022 hearing, my client taking the microphone from me and saying, you know what, we've heard you, and we're going to make all of these adjustments to our plan, and we're going to come back with a new plan that hits these requirements. I mean, I think that I don't see what purpose it serves to exclude all of that prior testimony and all of those prior facts from the board when considering this application. I think it's all relevant, and I'm not sure what fact-finding purpose it serves to exclude that. I don't quite understand the argument that the entire past proceeding is a nullity because the former board chairman was a member of SRD. I mean, the court just ordered that 8 members of the planning board had to be disqualified because they were members of SRD. We objected to those 8 members. We never objected to Chairman Reyna. And now the objectors are seeking to essentially take advantage of the fact that they had a member of the planning board before as a member of their group to disqualify 5 hearings worth of evidence that the board can consider in hearing this application. Again, I'm not sure what kind of fact-finding or just judicial determination purpose that serves. I don't see why excluding evidence from the record serves any purpose. We are going to present new testimony. We're not standing here tonight saying we're going to rely on those first 5 hearings, we're going to show you a plan, and that's going to be it. I have my architect here who's going to take you through the plan. We're going to present engineering testimony. We're going to present a professional planner. The board is going to hear plenty of testimony about the new plan. We're not just simply going to rely on the prior 5 hearings. But the fact of the matter is those hearings are all part of this case. This case has been going on for 2.5 years, but all of that information is relevant, I think, to the board's decision. And I just disagree that, as a matter of law, it needs to be excluded or anything like that. I also disagree with the characterization of Judge Minkowitz's decision that he somehow made a holding that this was a substantial amendment. He quoted the MLUL. I don't know that that was really relevant to the holding in that case, whether or not the application was a substantial amendment. The fact of the matter is, it is an amended application. We filed an application to address comments that we heard by the planning board, which is very commonly done. But I don't think that changes the fact that all of the prior testimony and all the prior facts that the board elicited should be part of the record. So I disagree that the application needs to proceed or needs to begin anew. I guess I'll rest there, Tom.
And Mr.
Thank
Warner,
you,
anything?
Mr. Goen.
Let's just make sure Mr. Warner has no rebuttal.
No, I do. Thank you.
Go ahead, Mr. Warner.
Again, with respect to the notice, the key issue is what was excluded as well as what was included. And it's one thing to leave out an item that everybody, including the court, ordering this board to consider as an open issue in the context of these proceedings. That interpretation issue ultimately, is this a permitted use or a conditional use requiring a D3 variance, or some other use or uses requiring perhaps a D1 use variance? A predicate issue. Is that something that's important and part of the nature of the matters considered? to reasonably apprise a resident, member of the public, to look into this, but also the misleading nature of saying, in effect, it's not. It's already been decided. This is a permitted use and in the zone. It's misleading. And as I said, with notice, it's a jurisdictional predicate. If it's bad, it's bad. And by the way, as we know, with the disqualification of a board member, I don't look, all I could say, all I go back on when I teach this, one bad apple spoils the whole bunch, right? That's what we learn from our board attorneys. You cannot have a board member, I'm on the record now, meaning what is the record? The fact that, and respectfully, I suspect applicant's counsel does understand the argument. So if the chair of the board was effectively conflicted and disqualified, I mean, let's look what happened. Sorry to be so colloquial, but the applicant decided they wanted to go after a certain number of board members. They picked them. They went to court and said they got to be disqualified because they were on that Facebook page. They didn't go for everybody. Didn't matter if the applicant was on the Facebook page. Didn't matter if people in favor of the application were on the Facebook page. This day and age, and I'm guilty too, we're on Facebook pages when we're not on TikTok. But that's a different issue. But the fact of the matter is, now you get your just dessert. You got it. You got the court ruling. Anybody on the Facebook page can sit on the dais. Well, guess what? Chairman Rena on the Facebook page not only sat on the dais, he chaired all the proceedings. Whoops. Oh, we don't want him off. Well, he's off. We don't want that to count. Don't listen to what the Randolph v. Brigantine case says. Don't listen to the fact that if a chairman presides over one hearing and is tainted, you got to go back and start all over again. Pretend that's not the law. Let's get the people off who we want to get off, but we don't want it to have to pay a price if we want to move forward and quicker and not have to go, and want to rely on 5 hearings from 2022.
Thank you, Mr.
And
Warner. Anything
Yeah,
further?
the rest, I just reiterate those same arguments, and I'd respectfully request the opportunity, whether it be 01 for these new proceedings or not, to present Mr. Collins the page that shows that Mr. Reyna is a longstanding or member of Smarter Responsible Development since early 2022. I have these for the board to demonstrate the
could be
factual predicate for my point.
That could be 01, yes. That's,
And with
you're
the
offering
chair's
it.
permission,
Show
I'll
it to the
bring them up.
applicant's attorneys. Let's just make sure, Mr. Goen, any objection to this being offered as an exhibit by Mr. Warner?
No objection.
Yeah.
Anything further? Anything further from Mr. Goen or?
Tom, real quick. So, I mean, relative to this issue of Chairman Reyna, I mean, it's, I understand the case law cited, but the conflict, the objector cannot benefit from the conflict. The conflict the taint follows to the objector. So, you can't use that conflict now as a sword. I mean, we were using, it's a shield for us. The objector can't use that as a sword. We can't have members of the dais who are inherently prejudiced against us. The objector can't now use that as a sword to say the entire 5 hearings of this prior proceedings are somehow tainted and you have to start all over again and disclude any of that evidence. That's fundamentally
today's date,
unfair.
though. Put
So
today's-
that's all I'll say about that issue. And then, again, relative to the record, we have review letters that we're going to talk about tonight. They identify this application as, the same application all the way through, application number 689. And the review letters also rely substantially and have a lot of discussion about the prior plans that we've submitted. So, that's something that we're going to talk about. I think it is relevant, the prior plans that we've submitted versus the current plans that we're going to talk about tonight. So I would ask that the board not exclude any of the prior record in this proceeding.
If I may, Mr. Chairman, just to be clear, what Mr. Goins just said is not the law. And I challenge him to tell me a case that supports it. If there's a taint, if there's a disqualified member participating, the hearings are void, you start anew. No matter who raises it, it's what's good for the goose is good for the gander.
And, excuse me, Tom. This board will decide if we're going to hear testimony from the prior application, or this is going to be new. Who makes that
The
decision?
board is going to make that decision, and tonight, probably. I just want to make sure we're done on these procedural arguments. Both attorneys are done. Are there any other attorneys representing a party in this proceeding who wants to make an appearance? There are no other attorneys, and it's about 8 p.m. So, very interesting arguments, okay? And one of the most interesting ones that you should probably maybe address first is really the issue of whether the case should start anew, whether the hearings from the past should not be part of this record, and whether the application as amended should start new hearings. And that issue is a very important issue in the entirety of these proceedings, including the appellate division decision and including the trial court's decision in the DCR versus Sparta Planning Board case, because Sparta Planning Board won that part of the case and actually contended that the amended plans were a substantial amendment to the application. And that does not mean that there needs to be a new application or a new number assigned. It just is a determination that the board can make that the case should start anew because it is substantially amended. And Mr. Warner is correct that the case law, actually that was the case law cited by the Sparta Planning Board to Judge Minkowitz in asserting that under Lakeshore Estates versus Denville and the Starry 10 case the Supreme Court entered, basically the courts have found that if the board finds that it's a substantial amendment to an application, then the hearing should start over. And that's your determination. If we go to that first, it actually helps to narrow the issues a little bit. There are a lot of reasons why it should start anew. The number one is the substantial amendment. Another one could be this alleged conflict claim as raised by Mr. Warner this evening. He is correct in asserting that any taint of a record could at any point in time result in the entire record being deemed null and void, which unfortunately means starting over again years from now, which I don't recommend to you. So you have to sort of weigh to what extent is it necessary to even consider the prior record, and if we decide that we're not considering the prior record, we will be requiring new testimony. The reality is there was going to be substantial new testimony on this matter because we never got through anything more than about 4 witnesses for the applicant and no witnesses for Mr. Dash. and no witnesses from the public, just questions. So, starting anew is, although sounds like it will take a lot more time, it might actually take less time because we'll focus on what is the application as amended presently before the planning board. So I think that's going to be the first issue I'm going to want you to rule on. I think that actually might narrow some of the other issues
So
too.
Tom, can we take a motion now in regards to that?
Yes, I
The
would.
chair will entertain a motion if this application should now start with new hearings. Do I have a motion on it? Tom?
Second.
Second. Dory,
Roll
can
call. Just the 5 people, not Mike Leondi.
Dory, can you call the roll, please?
Joan Furman,
Yes.
Ken Laurie,
Yes.
Ernie Reichstad,
Yes.
Mike Sylvester,
Yes.
Brian Zimmerman.
Yes.
All right, thank you.
So the board will not be using the old record for the continuation or for this application, this amended application. Now, there was another issue raised about notice, and I will go over that now. This one is my determination because it is jurisdictional, and it's important to realize that any application for any use requires a notice and requires to state that the applicant is seeking something. That does not mean that the board agrees that that is the permitted use or that they are not issues. That just means the applicant is noticing that a hearing will be held on an application. So that's true in every application. The objection by Mr. Warner, although well argued, is really not a sufficient basis for determining that the notice is defective. Mr. Warner and Mr. Dash and any members of the public will still have the opportunity in the hearing to contend that the use is not a permitted use or to contend that the proposed use does not conform with certain ordinances. It will always be, in every single planning board case, and is a case in which the applicant, in this case Diamond Chip, has the burden of proof that they comply with the ordinances. And it is not their duty to ask for interpretations or to take up the mantle of the objector's case and to state that this will be an issue in the case and in their notice. That doesn't mean that Mr. Dash or members of the public don't have arguments that they can make in the hearing. They absolutely do, and they absolutely will make those arguments in their portion of the hearing. But I'm satisfied that the notice is compliant with the municipal land use law and the case law. It adequately described the proposed application and that it met the standards of the case law, including the Pearlmark case. But I respect that Mr. Warner has a different opinion and Mr. Goodwin has a different opinion, and that may be a very important issue in future proceedings. But this case is a case which is a court-ordered hearing within 45 days of a court order. And this planning board has reconvened and accomplished the huge task of actually reading and considering that prior record and actually being able to be ready to hear the case. I agree with Mr. Warner that you probably do have 120 days from the date of this hearing to arguably to hear the case, but I suspect that we are going to be having multiple more meetings going well beyond 90 days, 95 days, 120 days, so much so that we will need extensions from the applicant, and they will probably be granted as long as the case is being processed reasonably. And that is what we do here in Sparta's, process applications reasonably. So that being said, I think you should start the hearing now if we have some time tonight. We won't have a lot because we end at 9:30 to 10, so no new testimony after 9:30. And that's the process that we're going to undertake.
Mr. Collins, if I may, since the decision's been made to start anew, does the applicant and their professionals have a change in their presentations, affect your presentations if we proceed to move forward?
Well, yeah, a little bit, but we're still prepared to move forward tonight.
Okay.
Now, I guess the question, Tom, I mean, one of the things that we were going to refer back to, obviously, was the changes that the planning board had requested. We're not going to talk about that. at
You
this
can,
point.
you can talk what you want to talk about, you just can't use the old record.
Fair enough. Okay.
Yeah.
Fair enough.
And that
So,
goes
no,
for,
I
that
mean,
goes for Mr.
yeah.
Dash and for the objectors as well,
And
so.
that's fine. So that's not going to affect our presentation tonight. We're prepared to move forward. Okay. So, Mr. Collins, we're ready to go?
I'm sorry, Mr. Chairman, I don't believe there's been a determination by the board on the issue yet. Correct, Mr. Collins?
No, I believe we're going to go forward with the hearing, Mr. Warner. We are not going to use the old record, but we are proceeding with the
I think
hearing.
he's talking
Right.
about notice, Tom.
I was referring
We're
to the
going to
notice.
proceed with the notice as it was done.
Oh, okay, would the board be voting on that?
No, the
Oh.
board will not be voting on the notice. Because boards don't vote on the notice. It's a question of law, so.
Okay.
And we understand that you object, Mr. Warner, and Mr. Dash objects, so.
Okay, very good. So I will begin our presentation with Mr. Richard Saunderson. He's the project architect. And I suppose at this point, we should swear Mr. Saunderson in and redo his qualifications.
Mr. Saunderson, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Please, you have to hold the mic, you'll hold the mic in the middle, and you both can speak into it.
Yes.
And please state your name, spell your last name, and give us at least a business address.
My name is Richard Saunderson. The last name is Saunderson, Saunderson. The business address is 545 8th Avenue, New York, New York. I'm a principal with Margulies Hosley Architecture at that address.
Thank you.
Okay.
Please go ahead.
And Mr. Saunderson, could you please explain to the board your professional qualifications?
I am a registered architect in New Jersey, amongst other states. I attended the City College of New York. I have a Bachelor of Science in Architecture as well as a Bachelor of Architecture, and have been practicing as an architect for about 30-plus years now.
And I would ask that the board accept Mr. Saunderson's professional qualifications.
Any questions from the board on the
May,
qualifications?
Mr. Chairman, may I respectfully voir dire Mr. Saunderson with respect to his qualifications before the board makes a determination on accepting him as an expert
That is
architect?
appropriate, Mr. Chairman.
Thank you, Mr. Chairman. Thank you, Mr. Collins. Mr. Saunderson, what is an AIA?
An AIA is a member of the American Institute of Architects. In order to use the AIA after your name, you need to be a registered architect in one or more states.
Are you an AIA?
Yes,
Okay, and you're a registered architect in New Jersey?
yes,
And is your license in good standing?
yes,
And have you been accepted as an expert in the field of architecture by land use boards in the state of New Jersey,
yes,
including this one?
correct.
Okay, but not this board, a formerly reconstituted board, correct?
The Sparta Planning Board, correct.
No further objection, Mr. Chairman, thank you.
Thank you.
We'll accept Mr. Saunderson's qualifications as a registered architect. Please go ahead, gentlemen.
Thank you. So before we start with the testimony, we do have an architectural exhibit that we should mark. So I guess, Mr. Collins, we're going to mark each one of these individually, starting with A1.
That's fine. And
Some of these were previously marked.
you start with new numbers with today's date.
Yep.
So we can know.
So I'm going to, yeah, we can show the old one. I'm going to start this with A1.
Now, these are not exhibits in your plan set. They're not exactly the same as your plan set. They're rendered somehow? Or are they exactly?
The board on the left was actually presented approximately 2 years ago with the original scheme. The board on the right and the other boards are the recent set of drawings, which was submitted as exhibits, I believe, by our.
I guess what I mean is, I was just trying to see if they're already in the plan set, so you didn't have to separately mark them, but if they look a little different in that they have a color on the,
I think we could just separately mark them. I believe that Exhibit A1 is part of the current architectural plan set that was submitted, but we'll just mark it as a blown-up version of
Okay.
whatever plan was submitted. And then, as Mr. Saunderson said, A2 is the prior concept scheme for the buildings. So, Mr. Saunderson, you were involved in the original design of this project, correct?
Yes, that's correct.
And you prepared the plans associated with both the original concept shown on A2, the revised design shown on A1, correct?
That's correct.
So, looking at the prior design and on A2 and the current design on A1, can you explain to the board the changes between the prior design that the board saw and the current design?
The prior design consisted of two buildings, the smaller of which was adjacent to the rail siding, the rail serve building. The two buildings consisted of approximately 506,000 square feet and 373,000 square feet, for a total of just over 880,000 square feet. The building on the left, which is closer to the street, actually was a double-loaded building, and the building on the right side, the rail serving building, was a single-loaded building in terms of the dock doors. The previous scheme actually had dock doors facing the street, which was noted by the planning board as a request to actually change. Furthermore, the previous scheme had storage in the front yard, which was noted in the three letters as something which we should reconsider. The current scheme is a smaller total square footage. It's approximately 698,000 square feet. The larger building is adjacent to not one, but four rail sidings, which are used for storage of rail cars. The building on the left, which is the smaller building, is also a warehouse building, and that's what we would consider a flex warehouse building. The building on the right is roughly a 43-foot, 5-foot height building. The building is designed as a storage warehouse, and the adjustments to the plan in response to the board's prior comments were to actually make this more of a campus-like setting. That's the general overall description of the changes.
So, and these changes were, obviously they were prompted at our last hearing before the board, but the items that the board was asking us to consider were outlined in a letter dated November 3rd, 2022, issued by Ed Hock. Is that correct? And you're familiar with that letter?
Yes, that is correct.
And what were the items listed in that letter that we were asked to consider in revising these plans?
We had 5 items actually in that letter. One of them was eliminating the front yard storage. The second was, had comment on the proximity of the building to the rail line, the rail-dependent use. The third comment suggested that we reduce the overall size of the warehouse. The fourth comment had to do with the retaining walls. The prior scheme had retaining walls within 25 feet of the front yard. And the fifth comment had to do with reducing the number of dock door positions that are on the buildings. And further, it suggested that we provide a more campus-like setting. Basically, buildings are related to each other.
And so looking at this revised concept, can you just explain to the board how you took a look at those 5 items and tried to address them?
Well, first and foremost was the idea of a campus-like setting. And what we did is we put the larger building further away from the street and the smaller building closer to the street. We actually narrowed the smaller building so that the length of the building is actually shorter than the long building, so that you can actually see the corners of both buildings as you approach from the street. Furthermore, we have removed the storage from the front yard, and the dock doors are now basically on an inner courtyard between the two buildings. That's where all of the truck loading bays are. The only parking at the front of the building is vehicle parking, car parking. Furthermore, we have, can I show the rendering at this point?
Sure. So,
This is A3.
yes. Could you first just describe it?
So now this is a rendering of the corner of the building as seen from the street. The second part of that exhibit is an aerial rendering which shows both buildings overall. So part of the camp
So
was like,
let's identify them first. So A3 is,
so
rendering of the
A3 is
corner.
actually our drawing number A002, and A4 is drawing A003.
And Tom, those are part of the architectural package that was submitted with the revised application. But obviously, we're marking them because these are blown up copies of those.
okay, they'll be part of the record, A3 and A4. Please go ahead.
Okay, so we talked about the campus-like response. We talked about the front yard storage elimination. I'm not going to address the comment on the retaining walls. The retaining walls is not really an architectural issue. That's really a site civil engineering design issue. It's my understanding those retaining walls have been reduced, although we're going to leave that for the testimony for the site civil engineer. I believe that summarizes it.
You went over the reduction in size of the warehouse?
We did. The total between the two buildings is 698,000 square feet, which is down from the 880,000 square feet. So essentially a reduction of approximately 200,000 square feet.
And also the number of dock doors has been reduced, correct?
That is correct. We currently have 102 dock doors for truck dock doors, 51 on each building on the inner courtyard. Previously, we had 192 at the first scheme.
And then just quickly, could you go over the, in terms of the proximity to the rail line, and we'll talk about it a little more later, but how that impacts the height of each building?
Well, the building that's adjacent to the rail line is the primary storage warehouse. That's the larger building. That is the building that can be higher than 35 feet because it is a rail-dependent use. As such, we've designed it to be 43 foot approximately to the ridge of the building. Why 40 feet high? Because it's a storage warehouse. And in addition to trying to maximize the flat floor level, we want to maximize the bulk. We're storing stuff. Basically, it's a building that's designed for what we call high pile storage, essentially storing items on racks.
Just to clarify one point, in the ED ordinance, the requirement for height is 56 feet for a rail-dependent structure, correct?
It's 56 feet as a maximum height, that's correct. Our proposal is 43 feet.
And the smaller building, how high is that building?
The smaller building is 35 feet, which is the as-of-right height for a non-rail-dependent structure.
Okay, so let's, referring to, I guess you can refer to both A3 and A4 if you want to give us a general overview of the architectural design of these buildings.
So these buildings are essentially, they're storage warehouses. So they're basically boxes. But what we do to articulate the building and give it some interest is we provide a pattern which actually reflects the concrete panels. These buildings are basically precast concrete structures on the exterior wall. That's typically how these are built. That is the proposal here as well. The buildings basically don't really need windows because they're storage warehouses. But what you'll see at the corners of the buildings are essentially curtain wall areas and glass doors. That's because these buildings are planned to allow accessory offices in the corners of the buildings, and in the case of the building in the front, a third area of curtain wall and entrance as basically as a key entrance to the building. So again, they're designed primarily as storage, so there's not a lot of windows, except at the corners where we designed for future flexible office space.
So Tom, I'm going to mark these as A5 and A6.
Okay, please identify them through the witness.
So the exhibit marked A5 is our drawing A007. The exhibit marked A6 is our drawing A006. The first exhibit, A5, is a floor plan showing the smaller of the two buildings. The second shows the larger of the two buildings. And let's start with the larger of the two buildings. The building is 570 feet deep by 1,000 feet long, or 570,000 square feet approximate area. It's a steel framed building with a 50 by 54 foot bay. Why a 50 by 54 foot bay? Because that's sort of the industry standard for a spec warehouse. It's a dimension that has been proven to be most flexible for a variety of tenants, or basically racking and storage of materials. The building is designed with what we call speed bays. In other words, 2 bays at the outside along the long sides of the buildings is designed basically with a larger bay, 60 feet, because that's where the circulation will happen. That's where the unloading from the trucks and the rail cars will happen, and the queuing up of the material for storage inside the building will happen. The smaller building is 150 feet deep by about 980 feet long. The reason being that this is intentionally shorter than the large building, so that you can actually see past it and see the large building from the street. Again, this is what we would call a flex warehouse building because it's meant for smaller scale storage and or the office space which would support the warehouse use, basically the front office or the accessory office. It also is a concrete panel building with, in this case, 3 areas, left and right corners at the front and in the center, designed as what we call storefront areas or curtain wall areas to allow light and an office entrance.
Let's bring up the elevations. And we're going to go to A7 and A8.
Could you let's just stay on the larger building and just would you explain, you described before the 4 rail sidings and you described them as rail storage.
Well, there's one rail siding which has a platform adjacent to it, approximately 950 feet long, which is for the immediate loading and unloading of rail cars. The additional 3 sidings are really for queuing up of cars to be loaded or unloaded that are basically on site.
What does that mean, queuing up? How are those going to be? They're not accessible to the building, right? They're not adjacent to the building.
They're not adjacent to the building, that is correct.
So what?
They're
So they just-
basically there because after one set of cars is unloaded. They can be queued out of the platform, and the other set of cars moved in, actually unload.
Does that mean that the contents of the rail cars might be full of goods during more than the day that they're delivered?
I suppose so, although that's not really an architectural question. I can't really.
But I mean,
give a whole lot
you
of
you
expertise
even
on
called it, you said storage.
that. That's right.
So
It's really,
you
it's
really
really a
think,
queue.
do you really think storage is allowed outdoors on rail cars? I mean,
Again, I don't.
where did you come up with that idea? You didn't have that before. I don't think there's outdoor storage of rail cars or contents in rail cars. That wasn't talked about.
Well, I think the comment, Tom, was outdoor storage of the rail cars themselves, not necessarily storage of materials in rail cars.
But if they're queued there, the way I understood it is you're going to receive deliveries of rail cars, and they're going to be adjacent to the building that's rail adjacent, allegedly rail adjacent, but yet the three rails in that picture are not adjacent. So they're not really delivery. You can't even take a delivery from the second, third, and fourth siding. So I have my suspicions, but that doesn't seem consistent with the concepts of the ordinance. So I'll just throw
Well, I
that,
just-
throw
I
that
mean-
out there right now, and I'm really having trouble with you having rail cars stacked queuing. That seems like it's more like a trucking, it's really more like a rail yard, and that's not something that's,
For our edification, can you just walk through that issue again, where the storage of rail cars is depicted on that site plan? I think
just with your
for
hand,
board
just show us with your hand where the
Yeah.
four rail sidings are.
And is this an architectural discussion
Well,
or?
it's on his architecture plan, and he did describe it as rail storage.
Okay,
I think
I mean,
that's the extent-
there'll be more testimony
there
by
will be,
the
yeah,
engineer.
there should be more testimony to that, or maybe operational testimony.
Where on the
but-
map again?
I'm sorry?
Where on the map was Tom referring to?
1, 2, 3, 4.
Thank you.
Can you define a set of cars?
I'm sorry, I didn't hear the question.
Can you define what a set of cars is?
I'm not sure that question is for this witness. I mean, any operational questions relative to the rails really for a different witness. From an architectural perspective, he could explain where those sidings are, but in terms of how they operate, nature of the cars and things, we'd have to have a different witness for that.
And just a note, after the applicant's professional is done testifying, then we'll open it up to our board professionals who might have questions, and then to the rest of the board members after our professionals.
Certainly.
All right? All right,
Yeah, certainly.
thank you.
Sure. Okay, so now we're gonna shift over to the architectural elevations, Richard. What were we up to? Tom, what were we up to?
I have,
6?
no, I think you're up to 9 now. Let me just check. I'm sorry, yes, now it's A7.
A7. A7 and A8. And Richard, if you could explain what these are.
So these two boards, A7, which is our drawing A009, and A8, which is our drawing A008, show the building elevations of both buildings, as well as on the bottom of the board on the left, A7, it shows a building section, a cross-section through both of the two warehouse buildings.
I'm sorry, Chair, for clarification, which one is which building?
Okay, good question. Starting on the left board at the top, which is Exhibit A7, is the west elevation of Building A. So this is the courtside elevation of the larger building. The next drawing, as you go down the sheet, is the east elevation of the smaller warehouse building. So these two drawings represent the courtside elevations, the inside elevations of the property. The bottom drawing on this first sheet is a cross-section through both buildings. So on the left-hand side is the street, Demarest Road. First, you see the small building, then you see the court between the two buildings, and then you see the large building, and then on the far right, you actually have a section through the rail siding.
That's looking.
So essentially, you're looking north. The drawing on the right-hand side has the north elevation of both buildings together. Okay, so this is the large building, the north elevation, and this is the smaller building, north elevation. In between is the court. Okay, so the street, Demarest Road, is to the right. The west elevation is the next drawing down. The west elevation is actually the street side elevation facing Demarest Road. So what you see is essentially the three entrance bays of the smaller flex warehouse building. Okay, so this is what you would see from the street.
You call them bays, but you mean doors and glass? Like they're not garage bays, right?
No, they're not bays. They're structural bays, not garage bays. And they're basically entrance bays for, again, huge potential office space on the inside of the building. Okay, the third drawing as we go down the board on the right is the south elevation. So the street would be on the left, Demarest Road, the small building, the court, and then the large building on the right. The last image at the bottom of the second board is the elevation at the rail siding. So this is essentially the east elevation of the large building, basically the back of the property.
Looking at these elevations, I think that would be an appropriate time. Can we talk about some of the design elements and building materials that you utilize?
So what you see when you look at the buildings is basically the precast concrete panels. That's what forms the facade of the buildings. It's the joints between those panels, which provides the vertical lines, the articulation. The finish on that concrete is typically a painted concrete finish. And again, what you see at the corners, on the first drawing on the board on the left, you see basically the truck docks, which again are facing the courtyard. And on the left and right-hand side of the building, you see the potential office entrances.
Definitely.
And one of the questions that came up, we'll get to the review letters in a minute, but one of the questions that came up in the review letters is the location of HVAC units and other building equipment. Can you explain where that would be?
We're really at the site plan submission stage, not the building submission stage, but typically what we do in these buildings, and I think what we had said 2 years ago at the prior testimony, was that we typically have RTUs, rooftop units, which are small packaged units. They're typically set back from the facade so that you don't see them from the facade. And they're typically multiple units, multiple small units rather than one large unit. Those we call them basically Cambridge units is the industry term.
And one of the other questions that was raised in review letters is whether any generators are proposed. Can you speak to that?
There are no generators proposed at this time. This is a spec warehouse building, and there are no generators proposed. That's correct.
One question that I think is important for the board to know is whether or not these roofs are going to be solar ready pursuant to state statute. Can you speak to that issue?
They have to be under New Jersey law. they need to be solar ready, which basically means for us building in a little extra structural capacity so that you can add at a future date the solar panels, the photo PV panels.
All right, so just turning to, we did get 2 review letters on this application, and I think I just want to reference them so that we're clear on what we're talking about. We received a review letter from Dave Simmons, and also a review letter from Catherine Sarmat. A stack of paper. Mr. Warner, you could have used this binder when you were doing that paper thing.
Now you tell me.
Eh.
Where were you when I needed you?
All right, so the the review letter from Catherine Sarmat dated September 13th, 2023. The review letter from Mr. Simmons dated July 20th, 2023. So when we're talking about planning and engineering reviews, that's what we're going to be referring to.
I'm sorry.
Yep.
You had clarification, Mr. Chairman, with your permission. Sarmad's report of what date?
September 13th, 2023.
Okay. And what was the date on Mr. Simmons?
July 20th, 2023. Oh, I'm sorry, we had a more recent one.
September 22nd.
September 22,
This,
2023?
That's the one, September 22nd, 2023, right, Dave?
correct, yeah, September 22nd, 2023.
Thank you. I thought I
Sorry.
heard a different date.
Yeah, yeah,
Thank
yeah.
you. Right, and you're welcome.
Thank you. So, all right, those, when we say planning and engineering review letters, those are the 2 most recent planning and engineering review letters that we've received, so that's what we'll be referring to. I think, we just walked through most of the architectural comments that are in those review letters. Basically, both review letters had the same comments, which was building materials, location of HVAC units, height of buildings, which we talked about earlier, generators. The last question was office space. I know you've touched on it, but what is the plan for office space in these buildings?
These buildings are designed primarily as storage warehouses. However, we know from experience that there will be a need for some accessory office space with the warehouse for, HR, IT, front of house office space. That's typically less than 10% of the gross floor area. In some cases, a lot smaller. And what we do typically, and I'll bring the floor plan back just to make the point, is that we plan the building so that the entrances are at the corners, where the most likely logical entrance will be for an office. The office is probably no more than a bay or 2, perhaps 2 by 2 bays.
You're pointing to an exhibit. What exhibit is
I'm
that?
pointing to Exhibit A6.
Thank you.
That, of course, allows the separation of the warehouse use from the office use, and you're not mixing the front of house with the storage use. So to answer your question again, Steve, there is no specific office space planned out at this time. However, it's anticipated that most tenants will have 1 or more accessory offices.
Okay, and then I think last exhibit will be 8 and 9? A8 and 9? Oh, I'm sorry, just A8. So this is our last exhibit. Can you explain what A8 is, please?
Sure. This is 2 images on this exhibit, A8, which is our drawing number A004. The top image is a photograph from Route 15 or Highway 15, looking towards the southwest. In other words, you're looking across another property towards the tree line. The tree line is at approximately our rear property line. So that's approximately 1,000 feet from Highway 15 to the property line. The image below is a photorealistic rendering on which we superimposed the proposed building. So if you look closely, you'll see bits of the building visible through the tree line, although from 1,000 feet plus, because again, it's 1,000 feet to the property line, and then our building is further set back from our rear property line. You get an image that represents what the view would be and how it would be impacted with the new building from Highway 15.
All right, so moving forward, in designing this building, you had a chance to review Section 18 of the Township's ordinance, which is the Sparta Comprehensive Land Management Code.
Yes,
And you are familiar with Section 18-4.29 of the code, which includes zoning standards for the ED Economic Development District, correct?
yes, that's correct.
From an architectural and design perspective, what requirements of the ED zone did you consider in this design? Maybe we should go back to one of the earlier exhibits.
Okay, so we're looking at Exhibit A4, which is the aerial rendering. And again, Steve, your question, it was,
Question is, what requirements of the ED zone, zoning requirements, of the ED zone did you consider in this design?
well, the ED zone has it permits a taller building for rail-dependent use. So the larger building, which is at the rear of the site, could be up to 56 feet high. Again, we're proposing 43 foot 5 inches high. And that, again, that additional height is permitted by the rail-dependent use. The building at the front of the site is limited to 35 feet high because that's the as-of-right height for the non-rail-dependent use.
I just want to clarify one point on the bulk requirement relative to height. The height bonus is permitted for a rail-dependent structure rather than use, correct? There are requirements that are applicable to rail-dependent use, but the height specifically is for rail-dependent structure, correct?
Yes, we're talking about the height in this case, correct.
So, and then relative to that, what is the intended use of these buildings?
Storage warehouses. Again, these are designed to literally house wares. They're designed to store products, most likely on shelves, but possibly on the floor, for a period of time, which could be a week or a day or longer. It could be a year. It depends upon the tenant and the actual end user. But they're basically designed to store products.
And you are familiar with the definition of warehouse in the Sparta Township ordinance, correct?
Yes. Specifically, it says, it shall mean a building used for temporary storage of goods, materials, or merchandise for later or subsequent distribution or delivery elsewhere for purposes of processing or sale.
And were these buildings designed from your perspective as the lead designer architect with this permitted use in mind?
Yeah, definitely. This is why we have a building that's 500 plus feet deep, 1,000 feet long, and has a volume that's 40 feet high. It's basically to maximize the storage volume in one structure.
We talked about the height standards already, and in addition to the zoning standards section of the ordinance, there's also a design standard section of the ordinance. And you're familiar with section 18-5.5, which are the design standards for industrial buildings?
Yes.
And did you have an opportunity to review section 18-5.5 in preparing this design of this amended submission?
Yes.
In your opinion, does this revised submission comply with the design standards in section 18-5.5?
Yes.
I really have nothing further for Mr. Saunderson, but I'll turn it over to board professionals.
Thank you, Ms. Goen. The board's in agreement. We'll take a 5-minute recess, and then after that, we'll have our board professionals, Catherine Smart and Mrs. Simmons, comment on any issues they may have.
Very good.
Okay? Guess we can start without Mike?
No, we can't
we'll wait
start.
till he
We
gets
need Mike
back.
in.
Take that as a message or what?
It's an open public meeting. We can't lock the door.
Sorry.
No problem, Mike.
Okay.
Mr. Chairman?
No problem. We're back in session. I guess, Catherine, would you have questions and comments to go first then? Yeah, thank you.
I'm like blocked off right here. Are we starting over? Are we starting now?
Yes,
Okay.
we're ready, right, Dory? Yes. You ready, Mr. Goin? Mr. Goin, you
I'm ready.
Okay.
Sorry.
You ready, Mr.? Yeah.
Yes, thank you, Mr. Chairman.
I know I'm hidden over here. I'm going to be asking questions on the board.
Catherine, do you want me to move these while you're?
If you want to move just the one, that'd be great. Thank you. So I have a few questions related to the architect's testimony. First, you mentioned that the material is largely precast concrete or concrete finish. What's the maintenance like on that type of material?
The maintenance really would be limited to periodic repainting because it's basically concrete, whether it's site cast or precast, either way it's concrete.
Okay, and how does it hold up to like discoloration? Does it need to be power washed frequently? Is it, stain easily?
I would say generally no. I mean, but like any other painted surface, eventually it will need to be repainted.
Okay, thank you. And how durable is that kind of material?
The concrete itself is durable, and this is concrete.
Thank you. What sustainable design practices have been considered in the design of the buildings?
Well, we haven't, again, these buildings are not fully designed. We're at the site plan review stage, preliminary site plan review stage. Again, one of the questions which came up earlier was the readiness of the roof to accommodate future solar panels. And that's really not even an option for us anymore. That recently became a law a couple of years ago in New Jersey that buildings of this size, or buildings with a roof of this size, are required to actually be solar ready. So that's kind of a given, basically.
Have any other considerations been made to sustainable design of the building from your end? Have you made any recommendations to the client?
We've talked to the client about it, but again, I think we're kind of early in the stage to make that kind of detailed commitment.
Can you give some examples of what kind of sustainable design practices would be incorporated in a building of this size or a typical warehouse?
We've talked about various LEED type provisions, LEED meaning the USGBC standard for leadership and energy efficient design. We have done many other buildings actually, which recently have, including industrial warehouse buildings, which have gotten a LEED status. We're working on a couple right now and actually in Pennsylvania nearby.
Thank you. I know you mentioned the building height for Building B, the smaller building, is shorter because it is not in the rail-dependent area.
That's correct.
This may be a question for another professional, but I appreciate that distinction was made between the two buildings for the height. But as far as any of the other kind of rail-dependent bonuses that are given in the bulk conditions for the zone, they were taken cumulatively. Was there any was there any kind of conversation or in your design of the two buildings, was there any consideration to how the impervious coverage might be impacted by the separation of the buildings?
I think that's more of a site planning question, so I think we'll defer to the site civil engineer on that one.
That's fine. I know you mentioned before, the ED zone does require, under its purpose, that it provide the type of uses that are permitted in a campus-like setting. I have, in the past been questioned, and I think it was brought up probably at well, we're not about to bring up the last hearing, but it's been brought up that that is not something that's held to or has standards within the ordinance. But you did mention that you believe that the design of the building and the site now does achieve a campus-like setting. Can you just describe
Sure.
what you put into the plan that you believe meets that purpose?
So part of the campus-like concept is that the buildings relate to one another, meaning that they're the same language architecturally. So these buildings are intentionally designed sort of as a big brother, little brother kind of a building. So they use the same materials, the same palette, et cetera. Furthermore, and maybe I should bring this up to show. This is Exhibit A3, which is the ground level rendering. So this shows a view which actually shows both the buildings in one view from the ground level. And the intention here, and I think we were successful, is that they appear to be related to one another. They're not unrelated buildings. They're the same language, the same style, so to speak, with a similar palette and the same materials.
Or you take that board you have, and if you could push it back so Catherine can see it while you're testifying. You can still aim it towards the public a
What
little
sheet is it?
bit.
Because I have them electronically on my
Oh, all right.
laptop, and
All right.
it's,
So we're looking at Exhibit A3, which is sheet A002.
I have that, thank you.
So it's called Ground View as a title.
Thank you.
I think to further answer that question, if you look at sheet A005, which is Exhibit A1, which is the overall site plan for the current scheme, you'll see that the front building is intentionally shorter than the rear building so that you can actually see the two buildings. And if you look at the corners of the two buildings, you'll see that they're intentionally articulated with a step pattern so that you actually define the scale and relate the buildings to one another by that pattern.
Did you consider anything besides the design of the exterior of the building, the relation between the two buildings in the purpose of a campus-like setting? The situation of the buildings, the setback of the buildings, the attenuation of the buildings?
I think it's important to remember that in response to the comment on the front yard storage, part of the site planning here was to make sure that the truck loading bays are on the interior court and thus minimally visible from the street, basically between the two buildings. So I think that's key. It's not necessarily a campus issue, but I think it's part of the idea that we want to make this, a cohesive project and in response to the comments of the board.
Thank you. Just some, feedback on my part. And I do think this was it is a very important part of the ED zone. It intentionally includes the purpose to talk about a campus-like setting. It doesn't say business park. It doesn't say office park. It says campus-like setting. And I think there's probably some intention behind that. You look at the word campus, the etymology of campus, it means field or an expanse surrounded in Latin. So it's intended to show that it's not supposed to, I think, be imposed upon. I think there's supposed to be something about it that is intentional in the ED zone, despite allowing for uses that are warehouses and industrial and manufacturing. And so that's why I kind of included that in my memos throughout the past 18 months or 2 years, just to say that it was a very important part. I think landscaping, I think building size, I think building mass, I think building height. I think number of buildings, it all plays into that. And while there are no standards, I think you definitely can elucidate that it was put there for a purpose, and an ordinance has a
No, I
purpose
think
and intent.
that's fair to say. I think the other point we should point out is that the building is now set back further from the street, from Demarest Road. So there is now more green open space in front of the building. It's actually visual, that's something someone on the street and the public can actually see. So it's the mass of the building is removed from the street side.
Would you say that an approximately 850-foot-long building provides an openness?
It's an 850 feet building that's several hundred feet back from the street in most cases, behind actually an existing tree line. So I don't think there's any point on Demarest Road where you'll actually see the entire building.
And do you, I know that so your sheet A003, which is kind of the bird's eye view, I don't have the exhibit number if you want to reference
Exhibit A4.
A4.
So if you, on that sheet, which I'll bring up, so Exhibit A4, sheet A003, the rendering does show the existing tree line, which is along Demarest Road. And that's existing today, and it can be enhanced by the new trees, which is as you drive down the driveway towards the building, those are new trees.
Did you have any input in the additional landscaping at the interior of the site?
We talked about it with the site civil engineer, although we're not landscape architects.
Okay. And you mentioned something about, the building not being fully visible from Demarest because of that existing tree line.
That's correct.
You believe that the trees that exist there in all seasons will help to mitigate the visual impact that the building has, the linear length of the building has along Demarest Road?
I would say yes. In fact, I drove by there tonight. I was here several years ago, a couple of times, several years ago. I think it was more of a winter time at that point. It was still, the trees provide a screening. There's no question about it. But they obviously are deciduous trees, and they're not evergreens. So
And is the site higher than Demarest Road? Would the buildings be located at a grade that's higher than Demarest?
I would say the answer is generally yes, although the site undulates quite a bit.
Thank you very much. I have no further questions.
And thank you so much, Catherine. David, you would have any comments on the architectural section?
Just a few, Mr. Chairman. Again, referring to the report that I prepared dated September 22nd, 2023, the applicant's attorney and their consultants addressed several of the comments in that report that I prepared, but just a couple, just to make sure the board is aware of what the general intent is. In general, for this complex, is the applicant still talking about several tenants or one tenant for the whole campus?
I don't think that's determined at this time. I think in an ideal world, it's one campus, one tenant, but in the reality, it may be multiple tenants.
So is it possible then, if there were several tenants you alluded on, especially I think to the front corners of the building, they might be separate office spaces for different tenants?
Separate tenants could be accommodated with this plan, yes.
Okay. Is there an upper limit on the number of tenants?
I think we would defer to the applicant on that. I don't know if there's a hard limit, because we could obviously, with some articulation, add additional entrances if necessary.
With regards to those office areas, I'm not sure if it was shown on the plans or not. Is there any proposed mezzanine area?
The answer to both is no. The office was not shown on the plans, and no mezzanine was shown on the plans as well.
No mezzanines at all?
That's correct.
I know you mentioned that you haven't designed it, which I understand, for the HVAC as far as those RTU rooftop units. Just looking at, what exhibit is that again? I'm sorry, it's on the board now.
The one that's up there is Exhibit A4.
just looking at the aerial view A4, that, as far as I can tell from here, doesn't show any RTU units on it. And I just want to make sure everyone has a good picture of what they're looking at. Do you have any approximate estimate, not holding you to it, but approximate estimate of the number of RT units that would be needed for a building this size?
I would say it could be anywhere from a dozen to 2 dozen. It depends upon the size of the units, which obviously is going to be dictated by the end user and what the conditions they need are inside.
Okay. And I know you're proposing for storage. Is there any consideration or possibility in any parts of these buildings to be used for frozen storage? In other words, freezer units?
A freezer building would be a very different building. It most likely would not be a precast building. It would most likely be what we call an insulated metal panel building. The program here is not for a freezer building at this time.
And you mentioned that no generators are proposed, nothing for life safety or anything in the whole building?
That's correct.
That's all I have, Mr. Chairman.
Thank you, David. Dory, we'll open it to the board members now. If you could call on each member to see if they have any questions.
Joan Furman,
I have a question between Building A and Building B where the docks are.
Okay.
And with regard to, it's difficult to get a scale because it's so large, but the distance between A and B. So you're going to have trucks coming in and they are going to be parked into Building B and Building A.
Correct.
And there needs to be a space in between, obviously, for travel. What is the distance?
The distance is not actually shown dimensionally on the drawing, but I can tell you from experience, it's approximately 200 feet.
So what is the length then of the tractor and the trailer?
We typically allow 60 feet for the tractor and the trailer for parking
Combined.
area.
So 120. And those trucks would be parked there for how long? In other words,
I
would there
think that's a
would there
function-
be
It's a
100?
function of operation. They could be there for a couple of hours, or they could be there for longer. It depends upon how long they need to actually do the unloading operation.
All right, I guess I don't know how to frame the question, but as the trucks are coming in and you have all these other trucks lined up, this takes into account for all the proper turning to get into the bay with trucks that are already lined there?
Yeah, that's an engineering question, but definitely, the planning is there for the circulation of the vehicles, yes.
Okay. I don't have anything else.
Thank you.
Ernie Reichstad,
I just had one question. I see on here you have,
Yeah.
as long as I don't break it. On each of the warehouses, you have, in addition to the trailer docks, you have 2 drive-in docks. What would be the reason for them? That's usually more typical of a distribution center, right?
Well, you need to get, for example, forklifts into the building. That's how you would bring equipment into the building. You probably would bring the actual shelving units in through those doors as well when you're setting up the warehouse. Whether or not they actually need 2 or not is going to be dependent on the tenant. We do many buildings where there's only 1 because it's not something that's used every day.
That's it.
Brian,
Not at this time.
Mike Sylvester,
Me?
Just one quick question. When you go back to sustainability, is the walkways and the connection between the buildings to and from each other, like, is there circulation with the walkways that you depict on that drawing? Are they connected to go from both buildings? Or are they just kind of individual walkways to get to and from in each building separately from the parking lots?
So you're
Do you
asking
have like
about
circular
pedestrian
walkability and
circulation?
circulation to and
Pedestrian
from?
circulation. I think that would be a detail on the site plan, so it's not something I really should comment on. I should leave that for site civil engineers.
And think the other one you answered. I'm good, thank you. No further questions.
Only architectural question I have is the 102 dock doors. Is the plan right now to install all of those doors and packages speculatively? Or are you going to do a half?
That's a very good question, because in many cases, the developer may not install all doors on day one.
Sure.
The provision is there for up to that number of doors. But obviously, until they have someone in place that's going to use all of those doors, it doesn't make sense to put them in. So they may be 1/3 of that number, 1/2 of that number day one. That's kind of a business decision that they'll be made when we're
And there
closer
hasn't
to
been
construction.
any dialogue yet in that regard to inform your plan set? Okay, that's fine. That's the only architectural one I have. Thanks, Dory.
Yes, what about the snow roof loads on these buildings?
Well, the buildings need to be designed to not only have the snow load, but, all the other loads that are required by code. So again, we don't have a structural design for this building, but the base bands which we show are typical for this type of building across the industry. And in addition to snow load, there's also the future solar load, solar panel load, as well as live load, and there's wind load, et cetera. So
Wind load too? Okay.
yeah, so obviously, the building will have to be designed structurally to code.
Now, do you have any fire safety zones within these buildings too?
Well, this building's design is a high pile storage warehouse, so there would be a fire suppression system, basically sprinklers, as part of the building. Typically, it's what we call an EFSR system, which is basically a fast-acting sprinkler system, which is what's required by the state fire code for this type of building, for basically high-piled storage.
Then when do you think you'll have the structural drawings available?
I think that's a little bit down the road. I think we're kind of at the site planning stage right now.
Yeah, but they'll be coming down the line, I
Certainly,
guess,
we'll have to submit full architectural, structural, mechanical, whatever you need for a building permit.
All right, that's it, Dory. Thank you. Any other questions from the board? If not, it's now open to the public. And please keep your questions pointed at Mr. Sutton, the architect, at this point. And please give your, sir, please give your name and address to our board secretary.
Robert Otto, 41 North Shore Trail.
And Tom, would you want to swear him in?
Yes, Robert,
Thank
please
you.
raise your hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, Robert.
I was just curious about the high pile storage. You mentioned that sprinklers are required. Do you anticipate additional permits? Do you know what kind of, I know this is all speculative, but combustible storage, is that anticipated? Are you planning for that?
So the answer is that high pile storage, which is basically any storage over 12 feet high, requires a certain type of fire protection system. And I'm not a fire protection engineer, but I can tell you that the EFSR system is typically the answer. The intention here is what we consider class 1 through class 4 storage. There's no hazardous storage intended here. This is meant to be dry storage, and it could be anything from, paper, food, anything that you use in your, daily lives, things that bottles of water, who knows?
So class 1 to 4, no, all right. And then just curious, because when you do the graphics, it is hard to tell scale. So obviously for the aerial, you had to do a virtual camera at a pretty high altitude. Do you know how high that was to just capture the scale of that in the surrounding
I do not know
landscape?
the exact height of the camera for the rendering, no.
I mean, probably, would you say at least 80 to 100 feet, or no?
I would say at least. And remember, really the intention of this rendering is to give an overview of the whole project. No one's ever going to see it from that angle unless you're up in the air. But it's to give basically a bird's eye view.
Yep.
Just to give a scale and perspective to the whole project as it would sit in the context.
I understand. Okay. And with the fire suppression, is the intent to control the fire to save the structure, even with class 1 to 4 as the intended storage? Would the goal be to save the structure or just kind of let it burn out?
And I think the goal of the sprinkler system is to contain the fire.
Okay.
Again, I'm not a fire protection engineer, but this is what's typically done in these buildings.
And then, I mean, this is a little backhanded, but you brought up the architecture. I'm not an architect. I'm just curious. So would it be fair to class this as kind of like a brutalist type? I mean, it's just basically a huge box.
I wouldn't call it brutalist, no.
Okay, what would you call it? Because it's
an-
showcasing the.
It's an industrial warehouse building.
Okay, all right. But you tried to soften the corners, as you said, and try to.
We did articulate the corners.
All right.
Because again, we have a desire to create a campus-like feel, as well as a building which is attractive to the community. Again, it's not just a warehouse. There's also going to be accessory office space as well.
So it's relational to itself in situ, but it's not necessarily designed to embrace the greater Sussex County people and nature together per se, just because it's industrial. It has to be the way it has to be. Okay, all right, thanks.
Thank you, sir.
Hi, Mark Scott, 9 Pueblo Parkway.
Mark, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes,
Please go ahead.
thank you. You indicated that the sprinkler system was state-of-the-art. My research suggests that the sprinkler system is really only to give the employees an extra 30, 60, 90 seconds to get out of the building. It's not to protect the building or the goods. What's your opinion on that, sir?
The sprinkler system is required by code.
That's just code, yes?
And again, I'm not a fire protection engineer,
Okay.
but this is a non-combustible structure, protecting meaning that there is a fire protection system,
To protect
which includes sprinklers.
to protect the employees, yes. All right. An average fire, the best fire truck can shoot 100 feet vertically. 100 feet horizontally, and approximately 150 feet vertically. Okay. Ms. Furman's point was that you're going to have trucks, 60-foot long trucks, parked in the middle courtyard of the building. So a fire truck that pulls up is only going to be able to put water into 40 feet of the building, right? 100 feet horizontally, 60-foot building, truck can't get past the other truck. It can only get 40 feet into the building. What are the dimensions of this building?
The large building is 570 feet deep, 5,000 feet long.
Okay, so we'll be able to protect with our fire department will be able to protect the outer 40 feet of that. So approximately 5% of the building. Is that the reason that you made this concrete panels so that when this is fully engulfed in flame, that the fire trucks can push the walls in and then put millions of gallons of water, which is today's technology, fire technology, for several weeks to put out the fire?
So, Mr. Chairman, I think we're ranging a little bit into commentary here and not question. And by the way,
I was just wondering why.
hold on. For your benefit, Mr. Scott, I just want to point out that we do have a letter from the Sparta Township Fire Prevention Bureau dated September 27, 2023, in response to this submission, which it says that so long as all work complies with the current building code requirements, the Fire Prevention Bureau has no additional comments or concerns of the plans as presented. So I don't think we need a whole lot more commentary about fire prevention. We've gone through that review with this set already. So if there's other questions for the applicant, we'll take them. But we've answered the question. There's going to be a fire suppression system in the building.
But it's more on questions.
Okay, so that was a one-sentence letter by the fire department, by the way. It's of concern because if you do have a fire, this building will be 14 feet above the aquifer, the Germany Flats Aquifer, which supplies 70% of Sparta's water.
But, Mark, excuse me,
What?
it was more questions
Okay.
of his testimony.
How are we, will this be put in a bathtub? How are we going to protect the runoff from the fire to get into the aquifer?
I don't believe that's a question for this witness, frankly.
Okay, I'll come back.
Thank you, Mark. Please give your name and address to our secretary.
Sure. Caitlin Gagnon, Summit Road.
Caitlin, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do. So I had more of a clarifying question. You had mentioned that in between the two buildings, A and B, the approximation of space would be about 200 feet to accommodate. And you said that's the average, so it actually has the potential to go up from there, correct? Okay. If that's the case, and scale, especially for us to understand as the public, is important, what do these renditions show in terms of spacing in between those buildings currently?
So again, it shows approximately 200 feet between the buildings, which includes the length of 2 stalls, basically, for the trucks backed up to the dock doors, plus the circulation aisle down the center of the building.
So that's what I'm referring to. In between the two buildings, that as shown in these renditions, it's approximately 200 feet of space?
Yes.
Okay, thank you.
Give your name and address to the board secretary.
Margie Murphy, Pueblo Parkway.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do. You had said, well, this rendering, believe me, I'm there every day and there aren't that many trees. I wish it were, but it doesn't look that nice. But you said that the building would be level with Demarest Road?
No, I'm not saying that. I think it'd actually be slightly uphill from Demolish Road
Slightly uphill.
because the site essentially slightly goes up as you move east of Demarest.
Right, but right now there are piles and piles of contaminated dirt back in there that since they've been digging out there for years, are the applicant going to be using those piles to fill in where they've been digging? And again, there's a lot of wetlands in there that are not shown on your diagram. How are they going to even that out? And what are we going to do with the wetlands, again, affecting our aquifer, which is our main water?
Well, I'm going to just point out that that's not a question for this witness, but it also gives me the opportunity to point out that we do have NJDEP flood hazard area and wetlands permits for this project. All that we need to build this version of the project we have received from NJDEP, and that went through a comprehensive wetlands, FHA, and stormwater review, and we received those permits in October.
But those are past.
That is for this version of the plans that you're looking at now with this application. So that is an effective permit that is recorded. And again, not a question for this witness. We'll address it more when we get to engineering.
So if it's not level, it's going to be above Demarest Road, the base of this plant or warehouse, correct? It's going to be up above.
Again, I don't think that's a question for this witness, so we'll address.
Well,
it
he's the
when we get to engineering.
architect, right?
I think you're asking engineering questions. You're asking for site plan and engineering.
Okay, how high are the air conditioners going to be above the roof?
The typical rooftop units on this type of building are 4 or 5 feet high.
And so it's going to be 45 feet, and then with another 5 feet, it's going to be 50 on the large?
That's correct, and keep in mind that those units are typically set back from the perimeter of the building. So they probably would not be visible at all from the grade.
But they'd probably be visible from Route 15 as well.
I don't think so, but again, that's something that's about
Okay.
1,000 plus feet away.
And parking?
Parking, I can basically tell you, is really a site planning question.
Okay.
The site civil engineer will address the parking count and the planning of the parking.
Okay. All All right, then I guess we'll have to talk to the other people about the wetlands and our water. Thank you.
Thank you.
Jennifer Derricks, tap into Sparta. One question. Where are the connectors?
Jennifer.
Oh,
Raise your
sorry.
right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please go.
Where are the connectors between the two buildings? In previous in renderings, there were 3 skis referred to as ski ramps between the two buildings. Is that still the scheme for this?
I'm not sure what you're referring to, the ski ramps.
Connecting the two buildings, it was, how are
There may
goods
have been
coming from
some-
one building to another, I guess would be.
There previously may have been some demarcation on the pavement or a circulation aisle between the two buildings.
So can you clarify then how are goods expected to move from the larger building once it's just taken off the trains and moved from one into the into the larger building and then into the smaller building, or is it just?
Another.
I think the short answer is no, that, again, that's a tenant-dependent use if the same tenant uses both buildings.
Okay, in the past it was, I understand we're on a different unit, but there's no expectation of connection between the two buildings. Going to what Catherine was saying, you actually testified about bringing the two buildings to a cohesive vision.
That's true, but I think that's more of a visual connection. It's not meant to be a physical
So there's no
connection.
physical connection.
That's correct.
Thank you. Please give your name and address to the board secretary.
Kathy Ebenhausen, Scudder's Road.
Kathy, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And Kathy, I hate to do this to you, but you do have to spell your last name.
EBBINKHUYSEN.
Thank you, Kathy.
All right, first question. Does the architecture of the building support both loading and unloading of the rail?
The architecture of the large building does, because it has a loading platform along the entire rear length of the building, approximately 950 plus feet long.
And how about of trucks? Same question. Does the architecture support both the loading and unloading of trucks?
It does on a different side of the building.
Okay. Can you describe how the architecture supports the negotiation of traffic between these buildings with the truck base?
I'm not sure I understand the question.
Well, this courtyard, right? The architecture of this building supports the negotiation of the traffic of these tractor trailers, right? How does the architecture support that?
I would say the site planning supports the circulation of the tractor trailers. The architecture is really the buildings.
Okay. What is the material of the courtyard?
The pavement material?
I'm asking, is it pavers? Is it?
Typically on a truck court, we would have concrete under the actual parking aisles and asphalt elsewhere. But that hasn't been discussed in detail with the owner. And again, that's really not an architectural question. That's really a site engineering question.
What is the pitch of the roof?
Pitch of the roof typically is 1 inch per, 1/4 inch per foot minimum.
Okay. I think I heard the answer to the question for HVAC, meaning how tall the buildings will be, but I didn't hear it for solar. What is the expected height of the buildings after solar?
Solar panels typically only add a few inches to the height of the building.
Will trucks be visible from Route 15 based on your rendering? Trucks in the bays?
From Route 15, I would say no. And the courtyard is not visible from Route 15.
What is the material of the roof?
Typically, we use a single-ply membrane roof. It could be what they call TPO, which is a polymer type of roof. It could be something else.
So that's not determined yet?
That's not determined yet.
You mentioned EFSR. Is that effective for plastic wrapped goods?
I'm not a fire protection engineer, but the answer is to a certain degree of plastic, yes. There's a quantification which the engineers use to determine what classification it is, and there are limits on combustible material.
Okay. Can a rendering be provided of the courtyard? It seems to be missing from all of the artifacts.
We can discuss that with the client.
For submission to the board, thank you.
Thank you.
Tom Eisenberg, 128 Sussex Mills Road, Sparta.
Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please go ahead.
Question for the board, or for Tom Collins, I guess. Does the ordinance require a campus-like setting? I'm going to go further on Catherine's questions.
Sir, we don't
questions.
answer your questions, but you can ask questions of the applicant.
Okay, does the ordinance require a campus-like setting?
The request was made in the engineering review letters that we consider that, and the applicant agreed, so we did pursue that as an answer.
Okay. These buildings are not brutalist, they're industrial, modern, trucking terminals or warehouse, whatever the board decides. We all know campus-like setting in Princeton is very lovely, and there's Madison and other places with beautiful buildings. I think a question comes up, and I'm leading to a question. Does a building like this belong in Sparta if we want campus-like settings, and the building is part of the setting? How would you define a campus-like setting, Mr. Saunderson?
I think the intention here with the campus-like setting has to do with the relationship of the buildings to each other and to the open space on the site.
Does it not have to do with how it all looks from the road or from someone walking by? I'm thinking of Princeton, which is the epitome of a campus-like setting with a campus-like building.
I'm not sure Princeton is a fair comparison.
Well, but this is Sparta, and the board gets to decide what goes in Sparta and where.
So look, I'm not sure I can answer that any further. I think our intention was to respond to those comments. Those comments did inform the refinements to the design, and I think it does meet that goal.
This is a question for the lawyer, perhaps. Does the board have the right to reject this proposal, this whatever it's called, based on that it's not a campus-like setting? Based on the building?
Sir.
Just try to keep it to the architectural question.
Well, it's a building, the architecture, I'm
But you're
just
almost
curious.
testifying versus asking questions of this professional.
Catherine was going in that direction, which is,
She
she's
asked
qualified.
questions. Tom, she asked questions. If you have any more questions, they're for the
Okay,
architect.
thank you, no, I don't.
Thank you. Please give your name and.
How you doing? Ryan Caruso, West Shore Trail.
Ryan, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? so
Always
help you
do.
God?
Yes.
Ryan, seriously, just yes? please?
Yes.
No commentary. Thank you.
Sir, in your, I think, 30 years' experience, how many warehouses have you designed architecturally?
Over the past 7 years, probably between 12 and 20.
Okay. So you're well experienced and versed with these structures and how they're put together and ultimately all the nuts and bolts that go into it, hypothetically, right? And so piggybacking off of Mr. Scott here, I'm not going to get into a fire suppression system, but in your year's experience, if a fire suppression system is inadequate and the response is necessary, what architectural design is put into this building in order to extinguish the fire?
Again, I'm not a fire protection engineer, but I can tell you as it relates to architecture, the fire code requires what they call ingress doors or access doors, which previously was every 100 feet along the facade, and in the newer code, it's 125, I believe. And those doors are not just for the egress of the tenants of the building in an event of fire. They're also meant to be for the fire department to access the building so that they can attack the fire and evacuate people from the building. So to answer your question, there are man doors or person doors roughly every 100 feet along the facade, which are for that purpose.
But structurally, I think you mentioned before, this is a steel building with concrete walls. Is there any tactics or ways that this building could be used to extinguish the fire other than manpower and hoses? From an architectural perspective and the
From an
way it's designed?
architectural perspective, it's a non-combustible building, so the building itself will not actually be adding fuel to the fire.
Sure, not the building not adding fuel to the fire, right? But in the sense that you have potentially 100 different trucks that surround the building, the goal is to not let it burn, but to extinguish. Obviously, fire could lead to other combustibles, which would be alongside the building. And so prevention of fire and/or extinguish needs to be done as quickly as possible, right? And so what would be the quickest way architecturally to extinguish this fire if the fire suppression system was not adequate?
I'm not sure I can answer that question. I don't think that's an architectural question.
So there's nothing in the building itself, either the walls or the way that the roof is architected, that could help or aid in the suppression of the fire?
Again, the building is designed to be a non-combustible building.
Okay. All right. Thank you. All right. Anyone else from the public?
Mark Scott, 9 Pueblo Parkway. Do you have a rendering of the side of the building where the trains will sit?
There is an elevation drawing, yes.
Can we see that?
Yes, you may. So on this exhibit, which is exhibit A8, the bottom image is the east elevation of building A, which basically is the rail siding facade.
How did the goods get from the building into the cars?
There is a platform alongside the rear wall and parallel to the rear wall. The rear wall is approximately 1,000 feet long. The platform is approximately 950 feet long. So if we take a look at Exhibit A1, what I'm referring to is actually along the right-hand side.
Thank you.
So there's a full-length platform essentially at the back of the building.
But there's nothing on the smaller building. Right?
The small building is independent of the rail line.
I thought this was all based on an approval for rail and buildings.
The large building is a rail-dependent building.
Apparently, yeah.
Yes. The small building is not.
How did you get the big impervious coverage and all these other ordinances?
Well, the height of the larger building is within the limit of a rail-dependent structure.
Correct. But the ordinance 2101, I believe,
Which is that the impervious question?
well, that's the ordinance that was designed to allow this building. That ordinance indicates that the rail-dependent use allows greater impervious coverage. That building on the side, the smaller building is not rail-dependent.
I understand what you're asking, and again, I think that the impervious coverage is a site planning question, and it should really be addressed to the site civil engineer.
But how can we give you an approval when that's not a rail-dependent building?
I think you're going to potentially give us an approval, not just on my testimony, but on the testimony of other professionals as well.
Once again, the goods come in on the trucks, and then they go into the big building, and then they go onto another mode of transportation, the train.
I don't know if that's necessarily true. This building is designed to store product. It could come in and out on truck, and it could come in and out on train. I don't think that
In and
there's,
out of truck, in and out of train.
it's a,
Truck, out train. In train.
again, I can't tell you exactly how it's going to operate.
Okay,
It's designed that either one could load the building.
okay, so both trucks and trains will be used here. Interact.
Potentially, the two could be used.
Thank you.
Thank you, Moore. Any other questions from the public? Please come forward, and just an announcement, we have 10 minutes left to the meeting. Your name and address to the secretary, please.
Adrian Meerman, 12 Brook Drive. Mr. Meerman, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Question for the architect. You mentioned the two buildings, one you refer to as a storage warehouse and the other as a flex warehouse. Is there a categorical difference in how these two buildings are used, or is that just nomenclature?
It's really industry nomenclature. They both would be an S occupancy category for storage as the primary occupancy.
Okay, you mentioned that the smaller building, the flex warehouse, is for smaller scale storage. Is that a different category of storage, or do you just refer to fewer goods?
Again, they both would be storage classification, but just by the very physical nature of the building. The smaller building, there's less volume.
And so when you mentioned smaller scale storage, that is not an industry term, that is just how you refer to it.
That's correct. It's, in other words, it's more likely a smaller tenant.
So for the larger building, you mentioned it on the perimeter of the actual storage area, so the interior. There, the bays are 50 by 54 feet. That is the optimal size for storage bays. And then on the perimeter of the storage space is a 60-foot logistical area. Is that on all four sides of the storage?
That is along the bay immediately behind the truck unloading docks and immediately along the rail loading platform.
Also, that referred to an exterior component, not the setup of the actual storage capacity inside the building.
Well, I think what you're asking about is the speed bay. Typically, that bay is left open for circulation, not actually used for storage. The reason being you need to get to the storage.
Correct.
And you need to unload physically the trailers or the rail cars.
So right, so. But wait a minute, he asked the question, he used the word exterior, and I don't think you're talking about exterior at all. Actually, my initial question was for the interior. Just wait, I just want this last question, it resulted in a confusing answer because you used the word exterior, he's talking about interior. I just I want that to be clear.
My understanding of your question, and tell me if it's incorrect, is that you're asking about the outermost bay on the inside of the building.
Correct. And that would be a logistical area to move goods from the loading area to the various storage modules.
That's correct. In fact, let's bring up the floor plans. We can show you.
And show this speed area.
So the typical warehouse user will actually leave this bay and this bay open or largely open because that's where they will actually queue the unloaded material and actually access the long aisles of the storage racks.
Left and right would not be used for that calculation pattern.
I've seen it done both ways. Some users will actually store all the way to the exterior wall. More likely, there'll be some kind of an aisle. That really is up to the individual user.
Thank you.
how would that same system work for the smaller building, the skinny building? Because if you have a 60-foot logistical area on both sides of the large building, you still have 450 feet left. But how does it work for the small building?
In the smaller building, we have the bay only on one side. So the first bay would be a 60-feet bay. The other two bays are 50-feet bays, which would be used for the storage or potentially the accessory office space.
Okay, and then no access from the opposite side to the building?
That's correct.
That's a blind
because you're
building,
actually doing the loading and unloading into the warehouse from one side only.
Okay.
Excuse me, Tom. Tom is your first name?
Adrian.
How many more questions do you
One.
have? One? All right.
Actually, I would like to introduce my question by referring that several residents have mentioned that the architectural style, the language that you call it, doesn't quite fit in Sparta. And Princeton may be a bridge too far, but I would like to just mention that my business is in New York City, the city that never sleeps, hard-nosed, no mercy for anybody who cannot make it. And yet, in New York City, large building complexes are given architectural relief on the exterior. They can be made to look like city blocks. They may be made to look like what used to be there before. It can be a large Con Edison electrical distribution station, and the exterior is given architectural relief. Now, I understand from your answer earlier that such a thing is not possible for this building. I would like to ask you, can you look at the exterior of the building again and provide relief along that 1,000 long wall, a foot long wall, the 570-foot long wall, and give that building a appearance through materials and architectural articulation that it doesn't appear like a monolith. The color rendering, I think the greatest feature of the color rendering are the clouds. But on the more technical renderings, where you just provide one after the other or one above the other, it really does look like a bunker, the way parking garages used to look. So I think it will go a long way if you make that effort. Could you do that?
We'll discuss it with the.
Just an announcement. Hopefully, Mrs. Sunday could potentially come back, or, with other questions from the audience, and so, because I'm very adamant
How many
about.
more questions are in the audience that haven't asked the question before?
Are going to have to come back.
We want them to come back.
Yeah. Because I'm very adamant about adjourning at 10 PM because we're all volunteers, so hopefully we can have them
We're
come back.
adjourning, we're adjourning in a few minutes, and we are not taking any more questions tonight.
Yeah.
The witness has to come back. The case is
We're not
still
forgetting about
ongoing.
you.
It takes
He'll come back
months
and
and
you'll have all
months
your
for cases.
questions.
No, understood.
So-
I think applicant's counsel was kind enough to acknowledge and
Hopefully, right.
stipulate to that, so.
Should I ask you, but hopefully he will, so. All right. All right, the hearing closed to the public.
We're going to be carrying this case until June 5th. We want to make sure. No comments. No comments or questions.
No, I'm very adamant. Again, he's going to come back the next meeting. and-
No. Chairman is in charge.
What time is it up there now?
Should we get a sign-in sheet?
We have
No.
4 minutes. 4 minutes.
Can you do it in 4 minutes?
Yeah. And I have one.
You don't have to, because you can come back next month and you can do it then.
Please give your name and.
Yeah, Patty Askin, Maple Parkway.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. I have a really hard time visualizing space. So looking at these, it's difficult for me. You said you've designed other warehouses. Can you tell me like where they are? Is there one this size that you've designed that's in New Jersey that I could maybe go and see? And then see how it operates and.
Or my firm. because I'm not the only one in the firm designs warehouses. So we could
Which is
definitely- If you, I'm sure if you Google our firm's name, you'll see a number of warehouses on on our website,
So we could go
some
and
of
see.
which are in New Jersey.
So,
Next to highways.
so if I'm correct, people are saying that this is about 1.5 times the size of like the Rockaway Mall. Are you familiar with the Rockaway Mall? Just to give me
Vaguely,
an idea.
I would say, I'm not that familiar with the Rockaway Mall. I was there many years ago, so.
Okay.
I couldn't compare it to the Rockaway Mall, but the building is, it's a large building, but the reality is that many buildings of this use are actually larger. We've done a few actually out in Pennsylvania that are significant.
Yeah. Okay,
So this
just one more, well, just quick, because I know we want to make this quick.
2 minutes to go.
You're saying the building, the non-rail use is 30 feet high, is that correct?
The zoning, or the
Zoning for
land
that.
use ordinance, basically the zoning limits the industrial buildings in this zone to 35 feet in height where there's no rail dependent.
Okay, and Sparta's a small town, and it's been here a long time, and I don't think at any point they imagined that there would be a large warehouse going in. I'm trying to wrap my head around this 50 feet. How long has that ordinance been on the books, that you have a height of a rail-dependent structure for 50 feet? Is this something that they've had on the books for years and years? Is this?
Nope.
Please,
I'm sorry, defer to Steve on that.
please, all right.
Yeah, I don't think this is the witness for that question, so we'll leave that one alone.
Okay, I'm just curious. It just seems very unusual to have
Like,
such
now,
a,
just make sure, you think we're going to hand a paper out with the names and
If
so
you want
forth?
to, Mr. Chairman.
Yeah.
it's up to you.
So you'll be at the next meeting, he'll be here again.
Great, okay.
And all the questions can be asked at that time.
yeah, I'm new to all this, and I wasn't here for all the other hearings and all the other things, so I'm just kind of
And then,
catching up. Okay,
Mr.
thank
Warner,
you.
you're welcome.
We have more time for questions.
No, 10 o'clock, no, there's no more time, 10
I
o'clock.
just have one quick question.
10 o'clock we adjourn, we're adamant about that because there's no way in the past.
I'm just curious if that's a rail
Yeah, no,
dependent
but we'll
building.
take your name and address and put it on the sheet.
It's just for the architect. Rail dependent question.
He's coming back.
Is it a rail dependent building or not? It sounds like.
Before we adjourn, may I just ask a procedural or process question, Tom?
Of course.
There seems to be a lot of concern, verifiable concern regarding the fire safety. Is it possible that we could request the fire marshal to come and address some of the questions?
Yes, you can ask the fire marshal to come, but he did write a report, so.
Okay, but we can ask him because
He's never battled
He
a
answered-
fire 10 times the size of
Okay.
this building.
And 3 people died on this.
Mr. Chairman, yeah.
Mr. Warner,
The board
you'll
wants
be
to-
back the next time in terms of questioning
Yes,
your questions with the professional. And everyone in the audience, please, whoever wants to follow up on the architect at the next meeting, we'll hand out a sheet of paper with your
to get a
name
list of
and
the
so
people
forth.
who want to ask questions of
What is
this.
this, Gary, too? What is this, Gary?
Do we have to go over meetings?
Yes, we're going, we need to go, carry to a
Excuse me.
date certain.
The date of the next meeting?
Yeah.
The next,
All right.
We need
I
you
ju-
all back June 5th.
Please,
We're going to do it again.
please, announcing the actual date for the next meeting. Good, thank
this hearing on the Diamond Chip application will be carried without additional notices to the June 5th, 2024 meeting of the board at 7 PM at this meeting room. There'll be no further notices.
Bring all your friends.
Thank you, Tom. Now,
Chairman, I'd like to make a motion to adjourn.
have a second?
Second.
All in favor? Aye.
Aye.
Thank you for all coming.